Gentleman from South Carolina is recognized.
Thank you, Mr. Chairman. Commissioner, Lois Lerner sat where you're sitting right now and said, I have broken no laws, I have done nothing wrong, and I have violated no IRS rules or regulations. Now, as a very highly accomplished attorney like yourself, you would have to concede that's pretty broad testimony, wouldn't you?
That's a statement, whether it's broad testimony and what its relationship is to the
No, it's broad. Your scope of cross-examination, if we'd been in trial, would have been unlimited. You mentioned a judge earlier, what a judge would do with this subpoena. Let me tell you what a judge would do with that testimony. You could ask just about whatever you wanted to ask. When a witness says, I've done nothing wrong, that is tantamount to saying, I've done everything right. I can't think of any testimony broader than that. So necessarily, our line of inquiry would also want to be broad. Wouldn't you agree?
I think your line of inquiry ought to be what it is, no matter what people have.
Well, no, you said a judge would throw our subpoena out, and I can't help but note you haven't moved to quash our subpoena, but you think a judge would throw our subpoena out as being overly broad.
If we were in the private sector, which we're not, the judge.
Well, I want to make it easier for you. How long will it take you to produce Lois Lerner's emails that don't involve 6103 material from January of 2010?
Well,
could we have that by Friday?
Absolutely not.
Why?
No way, because there's no way physically we can get
January of 2010. That's 1 month, no 6103 material, just email.
1 month.
Just 1 month. When can we get that?
We still, well, we have to go through each of those emails to make sure it has no 6103.
Well, how long is that going to take? Can we have it by Friday?
I have no idea.
Just 1 month, Commissioner. Just January of 2010. No 6103, and let me tell you why I'm interested in it.
No, well, I'll tell you, today is Wednesday. I'd be happy to ask the people who do the work and get back to you.
All right, let's do January of 2010, and then let's get ambitious and do February of 2010, and then let's go March 2010. And I think you know why I'm doing 2010, Commissioner. When the President likes 5-4 Supreme Court decisions, he calls that settled law, like the ACA. When he doesn't like 5-4 Supreme Court decisions like Citizens United, he attacks it, which is what he did in January of 2010. And that's why the timeline is so important, Commissioner. The jury is never entitled to know the motive, but they always want to know the motive. You don't ever have to prove why somebody did something, but the jury always wants to know, why did this happen? And if you start in January 2010 with the President's State of the Union address, and then you move through Lois Lerner's emails that have nothing to do with 6103 material, you begin to see a motive develop.
Great. You're going to get 20,000 pages of documents this afternoon. Some of them may well be January 2010. But I will check with our people, because if you would like us to stop that production of Lois Lerner emails and go to January 2010, I will go and find out exactly how long.
What I want is this. I want the subpoena complied with. I want it complied with in a timely fashion. And you and I both know that if there's no 6103 material, whether or not you think we need something or we ought to have it, or that we're on a wild goose chase, frankly, I could care less what you think about that. Our subpoena is our subpoena. If you don't like it, move to quash it. Otherwise, comply with it. Because you noted that our search was overly broad. I want you to tell me what search you would use to find an email where an IRS employee responded, "You who," when she was told that a Democrat won a special election. What search terms would you recommend that we use to find that email?
We've worked from the start of this investigation.
What search terms would you use to find an email where the response was, "You who," when a Democrat won a special election?
We might actually work together to see if there are search terms that would involve political campaigns, elections, political parties.
What search term would you use when Lois Lerner responded that a GOP Senate would be worse than a GOP president?
I would actually, if you wanted to, we'd go through and say, look at political parties, look at references to elections, GOP and Democrat.
Or we can do this. Just give us all of the emails she sent or received in January of 2010 that don't involve 6103 material, and we'll decide what we think is relevant and not. Because she said, "I've done nothing wrong, I've broken no IRS rules or regulations, and I have broken no laws. That is pretty broad, Mr. Commissioner.
Now, if I could just have a moment. This is exactly the discussion we've been having for the last year, and we'd be delighted to have, which is, out of the universe, what is it that you think would be most important? We'll give you the universe, but as I say, that'll take you more than this year. If we could figure out,
I just told you, it's January of 2010, because
January
that's when
2010.
that's when the Supreme Court issued its opinion in Citizens United. That's when the President of the United States famously, to their faces in the State of the Union, criticized that, and that's when Lois Lerner began to say, IRS can't fix it, we need a plan, we need to be cautious, we need to make sure it's not per se political. Let's start with January 2010. Can we have that by Friday?
And as I would say, I am delighted, and it's this kind of discussion, for instance, with the
Mr. Costner.
4-year worth of, could I just respond? With the 4 years worth of applications of C4s, we might be able to say, well, which ones would you like, so that we don't spend 3 years at it. January 2010 is a perfectly understandable definition, and we will actually respond to you as quickly as we can.
Commissioner, you need to understand our perspective, though. Maybe this started off as an investigation into the targeting of C4s, but when you have people who are supposed to be apolitical responding the way that she has responded, Tea Party dangerous, maybe the FEC will save the day, we got to make sure it's not per se political. When you have people in positions of authority and responsibility that are expressing overtly political commentary on government email, I think we ought to be entitled to all of them, and that's why we asked for it.
Chairman.
I would just simply note that, for the record, that you already have all those emails, which is why you have all of that information. So it is not as
we don't know what we don't know, Mr. Commissioner. We know the ones we have.
You know the ones we have, and
I got it.
we'll go to January 2000.
Mr. Costner, here's the
We now go to the gentleman from South Carolina, Mr. Gowdy.
Thank you, Mr. Chairman. Commissioner, you're an attorney. Can you explain for our fellow citizens what the phrase spoliation of evidence means?
I have no idea what that means.
Well, I'm going to help you with it. Okay? Spoliation of evidence is when a party fails to preserve evidence. There's a negative inference that the jury can draw from their failure to preserve the evidence. You with me? If you destroy documents, the jury can infer that those documents weren't going to be good for you. If you fail to keep documents, the jury can infer that those documents were not going to be good for you. You've heard the phrase spoliation of evidence, haven't you?
I can't recall ever hearing it.
It's true in administrative hearings, civil hearings, criminal hearings.
I practiced law once 45 years ago, gave it up for Lent 1 year, never went back.
All right. Well, let me tell you what you would have found if you had stuck with it. When a party has a duty to preserve evidence or records and they fail to do so, there is a negative inference that is drawn from their failure to preserve the evidence. It's common sense, right? If you destroyed something, the jury has a right to infer that whatever you destroyed would not have been good for you, or else every litigant would destroy whatever evidence was detrimental to them. Agreed?
I'm not sure. I think if you destroy the evidence and people could prove it, it wouldn't be a good thing for your defense.
Well, no, it's worse than that. The jury can draw, and they're instructed, they can draw a negative inference.
All right?
And that's true if a taxpayer is being sued by the IRS administratively, civilly, or prosecuted criminally, and they fail to keep documents, the jury can draw a negative inference from the fact that they didn't keep receipts or emails or documents. So if it's true and applies to a taxpayer, it ought to apply to the IRS as well. Agreed?
Is this a trial? Is this a jury? Is that what you're...
I said administrative, civil, or criminal. If you want to go down that road, I'm happy to go down it with you, Commissioner. In fact, I'm glad you mentioned it. You have already said multiple times today that there was no evidence that you found of any criminal wrongdoing. I want you to tell me what criminal statutes you've evaluated.
I have not looked at any.
Well, then how can you possibly tell our fellow citizens that there's no criminal wrongdoing if you don't even know what statutes to look at?
Because I've seen no evidence that anyone consciously...
Well, how would you know what elements of the crime existed? You don't even know what statutes are at play. I'm going to ask you again. What statutes have you evaluated?
I think you can rely on common sense that nothing I have seen...
Common sense. Instead of the criminal code, you want to rely on common sense. No, Mr. You can shake your head all you want to, Commissioner. You have said today that there's no evidence of criminal wrongdoing. And I'm asking you what criminal statutes you have reviewed to reach that conclusion?
I have reviewed no criminal statute.
All right, so you don't have any idea whether there's any criminal conduct or not because you don't know the elements of the offense.
I have seen no evidence of wrongdoing.
Oh, well, that's very different from no evidence of criminal misconduct, Commissioner.
Well, it seems to me if you haven't done wrongdoing, it'd be pretty hard to argue that you've had some criminal violation if you did.
Well, what did Lois Lerner mean when she said perhaps the FEC will save the day?
I have no idea
what did she say? What did she mean when she said we need a project, but we need to be careful that it doesn't appear to be per se political? You don't think that's a potential violation of 18242?
I have no idea if it...
Because you haven't looked at 18242, and you don't have any idea, Commissioner, you don't have any idea whether there's any criminal wrongdoing or not.
With regard to the production of the evidence, the production of Lois Lerner emails, I have seen no evidence of wrongdoing. What else went on?
Well, if there were, that would be a separate criminal offense.
What else went on with Lois Lerner, I've said in the past.
So what you're saying is you don't have any idea whether she engaged in criminal wrongdoing. You're just saying that you did not engage in any with respect to the emails.
I haven't seen any wrongdoing with regard to the production of Lois Lerner emails.
But you are not saying there was no criminal wrongdoing with respect to the targeting of conservative groups. I want to be very clear. You're not saying that.
I've made no judgments.
So you disagree with the president when he says there's not a smidgen of corruption?
There are people who have been making judgments both sides about whether there were...
And you know what? I'm not one of those. I'm just simply saying we will never know because you didn't keep the evidence. The evidence was spoliated. And whether it's negligent, whether it's intentional, whether it's reckless, we still don't have the evidence, Commissioner.
Well, you have the evidence that there is no emails from the White House. You have all of the Treasury emails. So the basic premise that this was an argument in a conspiracy driven by the White House does not...
No, sir, you're wrong about that. You're wrong about that. That you're repeating a talking point from our colleagues on the other side that we're obsessed with the White House. It was Jay Carney who perpetuated the myth that it was 2 rogue agents in Ohio. It wasn't any of us. Was that accurate? Was that first initial line of defense that this is just 2 rogue agents in Ohio? Was that accurate, Commissioner?
Not that I know of.
All right, so that wasn't accurate, and that came from the White House. Who said there's not a smidgen of corruption? Who said that, Commissioner?
My understanding is that was the president.
It was the president. So that's Jay Carney and the president both inserting themselves into the IRS scandal. And you want to blame us for bringing the White House into it?
I haven't blamed you at all.
You just did, Commissioner. You just did.
Well, it's a good argument. All I said was the White House has revealed there were no Lois Lerner emails. Treasury has given you all of their emails. So to the extent that the argument was that Lois Lerner was conspiring and emailing back and forth, thus far I haven't seen any.
But you can be engaged in a conspiracy that doesn't include the White House.
Gentlemen.
Good. Time's up. Right. Thank you, sir.
Well, I was wanting to let him go, but the guy beside me kept.
And so I'm sure you can appreciate the irony of Lois Lerner punishing people who want to educate their fellow citizens about the Constitution, and then she comes and hides behind it to avoid answering questions about her conduct. That's why people are upset. And then you add to that the President of the United States, the person who campaigned as the great uniter, that the same rule should apply to everyone, really didn't mean it after all. And he prejudges an investigation while the investigation is pending. So against this backdrop, Congress, I'm sure you will agree, has not only the right, but frankly an obligation to provide oversight over an agency where that is the prima facie evidence at bar. We have an obligation to do it. But the efficacy of our investigations depends upon the fullness of the information we're provided and the honesty of the witnesses that come before us. We are of no use if we have incomplete information or those that we seek information from are not truthful. So there's a piece of your testimony that has troubled me, and I want us to go through it. And this is what you said. Since the start of this investigation, every email has been preserved. Nothing has been lost. Nothing has been destroyed. So I want us to go through it. What did you mean by since the start of this investigation?
I meant since the response, as you note, the appropriate congressional response to the IG report in May of 2013, when the 6 investigations started. The investigations there, as I said, were 4 congressional, the IG and DOJ.
All right, so you and I are in agreement. You meant from the very inception of the investigation.
Correct.
And then your next, this is under oath. I think you'll agree it's material, it's important. We're not asking you about something unrelated to the investigation. It's under oath. The next thing you say is every email has been preserved. What did you mean by every email?
I meant by every email that the IRS had that I knew of had been preserved. That's what I thought. That was my honest belief.
Well, then why didn't you say that?
Pardon?
Why didn't you say that?
Well, if I knew then what I know now, I would have testified differently. But at the time, I testified honestly on what I knew and what I had been told.
Well, then
And
that gets us...
nobody regrets more than I do that in some ways this case has been the case that keeps on giving with new information coming out. I wish the information had all been out to begin with.
Well, Commissioner, it is always an option to say, I don't know. Loretta Lynch has made a living answering questions with, I don't know. It is always an option to say, based on what I was told. But you were incredibly definitive. You said, every email has been preserved. And then for those of us who may not have been paying attention, you said nothing has been lost. What did you mean by nothing?
What I meant at that time was I had been advised nothing. But you're exactly right. In retrospect, I would have been better advised to say to the best of my knowledge or on the basis of what I've been told, which was, in fact, the basis of my testimony.
Well, I'm out of time, but this is what I would like you to do, because this is an important matter. I was one of the folks who wanted this hearing. I think this is really important. And you should be able to provide us information, but Congress should have all of that information.
Exactly.
So what I would like for you to do for me is you use the word mistake. That is the lowest level of scienter. There's mistake, there's reckless disregard for the truth, there's a deliberate indifference, and then there's intent. I'd be curious what you think the proper punishment is for each level of that scienter. And the other thing I need you to do is, to the extent you relied upon other people's counsel or what they told you, I need to know who they were. This committee, and I would think you would want us to interview every single witness that has access to information that would be relevant.
I think you have interviewed all of them already.
So you cannot think of a single person that this committee should interview that we have not already interviewed?
As to my knowledge at this time, you have interviewed the first 50. I don't know the names of all the 50, but the people who advised me throughout this case, you have interviewed.
Would you do me the courtesy of making sure with your lawyer that the record is complete? Because whenever the record is complete, that's when we have to make the decision. And I am giving you the opportunity, under the heading of due process, to make sure that every bit of information you think should be considered is in fact in the hands of this committee.
Well, I would just note, and without going into detail about it, there's a lot of information and misinformation and misinterpretation of it that's in the hands of the committee. And if there were going to be a full hearing, I would have the opportunity to explore that. We would be able to cross-examine witnesses. We would be able to actually provide you not just the allegations being made, but the facts on both sides. Each side would have the opportunity, but the impact of the facts. You should hear from the Inspector General directly. Who did he talk to? Is he still, as he said in his letter, confident that it was an honest mistake by 2 employees, it was not purposeful? You should
That's what I'm asking.
Yeah.
Give me a witness list, because you can't cross-examine them until we have examined them.
That's correct. I'd be happy to provide you the witnesses and the information that this committee would need to be able to actually proceed accordingly. But as noted, that would be if the committee decided it wanted to go to a full-scale impeachment process, which I understand this is not.